Philip Ellison, appearing on behalf of certain objectors who are joining me in the courtroom today, as well as on behalf of the Higgins Lake Property Owners Association.
Welcome.
Your Honors, the issue today that's before you is starts basically from the aspect that Roscommon and Crawford counties filed a petition asking the circuit court to allow them to create a special assessment district, but the request didn't have any project defined. It didn't have any cost estimated or even listed as a total amount. It had no allocation that each property owner who would be part of that special assessment district would be responsible for, and I think the most important part, did not establish the benefit that is constitutionally required for a type of special assessment. The circuit court, despite hearing all of these objections repeatedly, and I think one of the cute lines that Judge Bennett said in that hearing is the mood of the room is against what I'm doing here today. However, despite all those objections, he rejected every objection and granted the petition. But on the understanding, on the assumption that he likes to say, I'm not the tax man, I have nothing to do with the assessments. And we think that is a structural error of how this whole entire process is supposed to work. Our reading of Part 307 is there's two aspects to it. There is the establishing the lake level order, which is a case I've been before on the chill, we call it the chill case, the Citizens for Higgins Lake legal level. And this is the second part that does allow, and there's no dispute, it does allow for a special assessment district to be established. The problem is that the process that the counties have undertaken has said, we will establish the district and we'll let you know what amount, what your allocation is, and what we're going to do, anything later on. That bifurcated, or sometimes called multi-step approach, is inconsistent with what 307 actually provides. But even if 307 is if that is how the system is actually written by its plain language, it has to be unconstitutional because it doesn't allow for apportionment or allocation challenges.
Yes, yeah. Untangling the statutory scheme, I think, is part of the challenge here.
I agree.
So I see, MCL 324.30714. That talks about the making of a special assessment roll that describes the parcels of land to be assessed, the name of each owner of the parcel, and the dollar amount of the assessment against each parcel. And there's the delegated authority shall set a time and place for a public hearing on project cost and the special assessment roll. At or after that hearing, the authority may approve or revise the cost in the roll. And then the special assessment roll with the assessments listed will be final and conclusive unless appealed in a court within 15 days after county board approval. So my understanding, and you can correct me if I'm wrong, is number one, none of that has happened yet. I take the court's ruling to say all of that is yet to be done. And when that's done, that's when you can go to court and bring these challenges to the roll and the cost that was approved by the county board and all that stuff. And what I'm doing here is just sort of the boundary setting. So that's, I guess, number one, that's my understanding of what the court did.
That is correct.
So then what is, and it sounds like a lot of the concerns that you and your clients are raising are ones that are encompassed by and contemplated by that statute. Is there anything? Yeah, I see costs, I see the assessment amounts, who's being assessed. So it sounds like you still have an opportunity procedurally to challenge all this at the county level and then at the judicial level. So what is what's inadequate about that? So
the short of it is and again, I'm coming to you, I guess, kind of twofold. And I think you correctly identified is one, we need to untangle how do you read these, what's the procedure, what's the steps that this process provides. And it's our position to answer kind of your first part of your question to say is all this should be done before the court holds its, and I nicknamed it the fairness hearing, right? It's the review hearing in which the court reviews that whether the proposed special assessment district is in fact proper with the, constitutional obligations of proportionment and proportionality and allocation that our takings and due process clause require for special assessment districts. The problem that I'm struggling to understand from this approach is how would a court know who would be in the special assessment district if you don't know what the project is and who's going to benefit from it? Because a allocation of or I should say the imposition of a special assessment district requires rough benefits to be received by the people who are actually paying that special assessment district.
Right, and it sounds like, that from my understanding, there's a methodology in terms of who has direct access or indirect access and sort of setting the boundaries in that respect. And then, I guess what I'm wondering is with the statutory procedure I just laid out in that one provision.
Correct.
I guess what prevents an individual at that time who says, hey, I really shouldn't be assessed anything meaningful with respect to this by virtue of my circumstances. My inclusion here is really tenuous at best. What prevents them from raising their hand at that point and saying, listen, once there is an assessment being put out, that listen, this shouldn't cover me. It shouldn't cover me the way you're saying it should. Why can't that happen? Our
position is that they should be able to raise that issue. And I'm going to come back to a point you just made in just a second. But to answer your question, it's our position, the way you read the statute is that gets to be brought up at the hearing scheduled at the circuit court in section 30707. Meaning this is the preliminary work that needs to be done. Because the one point you just made right now, and it's one example of many that, for example, pretend you're an offlotter or a backlotter saying, I shouldn't have to pay for whatever this project is. And again, there's kind of some built-in assumptions that are being baked into this, like this is going to be a project for X. We don't know what the project is. In fact, the project's never been defined as to what's actually being done for Higgins Lake. So maybe it's, pick a weird hypo. We're going to bring 10,000 trucks of water in to raise the level of Higgins Lake. A backlot owner could say, I shouldn't be involved with this at all because I'm not even on the lake. It doesn't benefit me. Contrast that with someone else's interest that says, I am a front lot owner, but I think it's being unfairly allocated because the south side of Higgins Lake has 100,000 people coming through the state park who are utilizing that property more. That allocation is unfair in this respect. None of that can be raised because none of this has been done now. And essentially the circuit court proceeding, if we adopt the county's position on that approach to say you can do this bifurcated aspect, what was the purpose of holding a hearing in front of Judge Bennett? It would be a pointless exercise. It's our reading of the statute, which would be more consistent with the constitutional obligations to establish a proper allocation and proper proportionality, that the steps that should go forward is the county defines, we're doing this project, whether it's a new dam, whether it's bringing in 10,000 trucks, whether, we're going to shoot rain clouds above, rain seeds. I mean, you pick whatever your project is. Then you had defined the cost, and those costs then are, and because that's part of your preliminary study that's done under, that's provided for under the statute. And then those costs are proposed to be allocated in a particular fashion, whether it's everybody in the county, whether it's all the lakefront, whoever in this respect. And then anyone that wants to object can come to that hearing that is scheduled before the circuit court. And the circuit court then has a substantive obligation. Not the joke almost is this, if we boil it to its core, and I don't mean to be disrespectful to a court in this, but in this respect, he's nothing more than someone serving coffee in a forum for people to come in and complain with no substantive responsibilities whatsoever. The point of that hearing is so that the judge gets to make sure that a proposed special assessment district actually complies with the constitutional and statutory obligations of proportionality, allotment, basic equitable fairness.
I guess my question is, so it seems like maybe there are a couple different ways you can do this. Perhaps, maybe there is a, let's say the scenario is the county comes and says, yeah, we have a project about maintaining the lake level.
Right.
Okay. So that's our project. And we have a special assessment district that we want to approve, and it comes to the court to get that district approved. And, I guess what I'm wondering is, simply because here there wasn't as much substance as there could have been in this hearing, how does that prejudice your clients from being able to still be able to raise the concerns they have about whatever the project does end up being, when that project does in fact come to be?
So the answer, the short answer is I'm going to rephrase your question. I think respectfully is assuming we can do this, set the boundaries first without knowing the project and the cost and the allocation. We set who's going to pay the bill, and we'll let you know what the bill is later and what your portion of it is later. Is folks get due process on the first part. They don't get due process on the second part.
Why not? Why not?
There's no follow-up notice requirements. All the notice.
It's a public hearing, right?
It's a public hearing, but the notice for the hearing with the judge, it requires notice to be sent out by the government before to have that hearing. The second step process that's provided for does not have any notice requirement under the statute.
And I guess, but I suppose, in some ways, I understand what you're saying. There's no immediate prep. To the extent there's no immediate notice of that public hearing. I mean, it's certainly, this first step does, if I'm a landowner and I've been designated for the special assessment district, that's some pretty advanced notice to be aware that this is something that could be coming down the pipe.
But in fairness, though, to the property owner, they get a notice that says you might become part of a special assessment district. They have no way to judge whether that special assessment district is fair, if it's been properly allocated. Is the people who are being designated to pay actually the true benefit? Because again, this constitutional standard for a special assessment district is that there has to be, and I'm going to use the phrase rough proportion. They've used different phrases throughout the last 100 years of the case law. But I use the phrase rough proportionality between the benefit received and the allocation of your cost to that aspect. There's no way a property owner could know that. So for example, and just as a weird example, I'm from Saginaw County. We live in a swamp. I mean, Saginaw County is a former swamp that got drained, 200 years ago. We have a special assessment for drains in that jurisdiction. The drain cost for me is about $8 a year. It doesn't cost me very much at all. I don't mind paying that contribution. But if the county's position on this bifurcated approach would be is that the drain commissioner would say, oh, we're going to put a new drain assessment on you. Okay, great. The most I've had before is $8. They establish my properties in the district, and then all of a sudden I get an $80,000 bill because they're going to build a giant aqueduct. I never had that opportunity to challenge that proportionality, which we think should occur at that circuit court hearing. And that may be our fundamental difference between our positions right there, is the when.
Right.
Okay. And I will say one of the things that's interesting about this statute is this statute's about 100 years old. This was here largely before a lot of our due process and special assessment case law came into it. Got vacuumed into Part 3, the NAREPA, into Part 324 or Chapter 324. It's Part 307 of that. I think this law has just never had any attention to it, and it's been utilized in large respect because it hasn't been very expensive. The project here, for example, I can pick, and I've given some kind of outlandish examples of, seeding the clouds and bringing in trucks. What if the county decided they wanted to repave I-75 during their portion of the property and say, because it benefits the Higgins Lake, and that's a cost that we're going to pass on to the lakefront property owner? That would be asinine, right? I think it would be unfair. When would they bring up that? Because
why not when the special assessment roll is made and the project is saying, and they've gone forward, that the special assessment roll is determined, the assessment is listed. Why not at the public hearing then?
Because there is, be clear, there's the judicial hearing and then there's the public hearing we're talking about. You get notice as a property owner of the judicial hearing. You don't get notice of the hearing for, you don't get the project itself.
But so that's a little separate, set the notice distinction aside. Let's say I'm at the hearing.
Right.
What stops me from raising all these arguments then?
You could raise, I think you could, in fairness, the short answer is I don't know, because there's been no case that's ever dealt with this before. We even talk about, you said there's the language in there about appealing that. Where do you appeal that to? Do you appeal that to the circuit court? Do you appeal that to the tax tribunal? Do you appeal, where do you go with this? I mean, it's my belief that the real reality is that how this process should work is before the local circuit court holds its hearing, and I know I'm somewhat repeating myself, but bear with me, is that all of this work is done so that when a property owner has full information in front of them to say, here's the proposed project, here's what it's going to cost us, here's what my allocation is, and here's why and the amount that I'm paying I can see is going to benefit me in rough proportionality, it's constitutional. If I have information, for example, paving the I-75 example, and I get an $80,000 bill for repaving I-75, which is not connected to the Higgins Lake, I'm not getting the benefits from this. Other people are getting the benefit from it, and the allocation is unfair. It's our position that due process requires that be done with the circuit court process. Now, if this court concludes otherwise, we need to know that and the real reality is let's just take, and I guess I would invite the court then is if you're going to go the other way, which we would strongly advocate you don't, obviously, we would advocate our position is the correct one. But if you were to adopt the county's position, we need guidance on where do you go? Because there is no longer a hearing. There's no longer notice, and I say a hearing, a judicial hearing that's provided, and there's also no notice to us individually about to go out and to challenge these special assessments. What it is, it's no different than a public hearing that's held at among the many that the County Board of Commissioners hold on an ongoing basis. This process, and I come back to where I start from on this is to say this is structurally in error. This whole process of this dividing aspect is structurally in error because it denies the cost and allegation information to be objected to on a proper basis. And what I would kind of parallel this to, I guess, is kind of my final thoughts. And of course, I'll answer any other questions the panel may have. But I'm from a little town up halfway between Saginaw and Midland, and my wife's on the school board. And they passed a millage to raise $40 million. And no joke, $40 million to basically rebuild the schools up in our area. It was a major political push. It was a major expense, a lot of money. Myself, I own a business that's there. I pay tax on. I have a house. You probably can guess how I voted because I live with my wife who's twisting my arm before we walk to the ballot box. But nonetheless, if the county's position is right, what the school could have done is say, we want to go to the voters and ask for a special assessment. We're not going to tell you what the improvements are. We're not going to tell you how much it's going to cost. We're not going to tell you what your cost is, the property. We want you to establish the boundary of the special assessment district voters, and then we'll let you know later. And then my school district, in a fit of craziness, decides to open an auto repair shop on there and use the money from there for that. Now, that's an outlandish example, obviously, but it highlights.
We're mixing contexts.
But
I understand.
But it's the parallel. It's the parallel. In this instance, the special assessment is allowed to be placed by the county petitioning a judge as opposed to going to the voters. And that's an issue for another day. But the issue here right now is when does that information have to be given to the individuals in order to comply with, I think, fundamental fairness, and fundamental fairness in our system is the label we put on that is due process. So what we're challenging here, to finish my thought here today, is we're challenging the structure and the process and the step 1, step 2, step 3 of how this statute should be read. And if it allows for that kind of process, that's why we have the constitutional challenge at the end of our brief to say, if this is how you agree that this multi-step process that puts the cost and the project definition and everything else to later without notice and opportunity to be heard, because again, it's notice and opportunity to be heard. It's not just post a public notice on a door that you could show up. If that's the case, then this statute, as it's been designed by the legislature, is unconstitutional, and we would ask the court to strike it. Unless the court, Judge Maldonado, you've been off in my peripheral view here with the cameras. I'm happy to answer any other questions that the panel may have today.
I don't have any questions.
All right, very good.
All right. None for me for now.
Thank you very
We have
much.
a few minutes for rebuttal.
Thank you.
I'm going to say good afternoon instead of good morning.
You got it. Yep.
Yeah,
Nailed it.
Stacy Hisson appearing on behalf of Roscommon County and Crawford County with regard to Higgins Lake. So where I think the confusion is for appellant's counsel is he's confusing the establishment of a special assessment district that stays in perpetuity with the levying and collection of special assessments that are for different projects during the life of a lake level. So what the process makes sense for a reason. And so you have the establishment of a lake level. And for this situation, this occurred over 100 years ago.
Last
Then
time was 2009, right?
the original establishment of the lake level was 100 years ago. So there was some revisions to the order under the court's continuing jurisdiction.
Right, but we had
in
a
2009.
reestablishment in 2009.
I wouldn't call it a reestablishment. I think there was some revisions to the court order. It was not necessarily a reestablishment.
What's the difference, I guess?
Well, if there's a change to the lake, in my opinion, there is no reestablishment. There's continuing jurisdiction to revise the court order, which may include the revision of the winter and summer level, a change to the boundaries, the time frame from which a winter to summer level changes, et cetera. And so there's the establishment of a lake level. The court has continuing jurisdiction to make changes during the life of that lake level. There's actually no statutory provision to dissolve a lake level once it's established. During that time frame in this situation, over 100 years, there's going to be changes that need to take place to that water control structure. Dams don't last over 100 years, or shouldn't last. There's going to be, in due diligence of a county, things that happen over the centuries, perhaps, that require the upkeep, that mandate the upkeep of a water control structure.
How do you know what the right district is without knowing what you're going to do? I mean,
Okay.
there's some,
Yeah.
there's some very
I'm getting to
fundamental
that.
intuitive appeal there, and there's also some statutory connection there where it talks about establishing the lake level and or like determining that and establishing the
district.
district. So I mean,
Okay.
help me
So
understand.
yeah, I'm gonna get to that. So once you have a lake level, then the county has the responsibility to take care of that. And then the county also has some decision-making to do since 1969. Before 1969, it was county general funds exclusively that paid for that. But after the 1960 amendments, the county had the right to establish a special assessment district. You do that once. You don't do that every time you levy a special assessment for the multitude of projects that could take place over a period of years.
I mean, how do I know that from the statute?
Because
Because it seems like, you can determine a lake level, but presumably you can redetermine a lake level at times, right?
you can revise what the
So why
the
is
lake
this,
level
why is the
is.
special assessment district this one-off proposition?
So because you're established, because the court has taken jurisdiction over the lake level, and so the county decides, should there be a lake level and should we have a special assessment district? The circuit court decides what that lake level should be, whether there should be different levels. The circuit court makes that determination, and then the delegated authority takes the actions to operate, maintain, and improve those, and in some instances, construct the water control structure in the first place. So if this court was to read that every time there's a project, we have to go back to circuit court to have a new boundaries of a lake level established, I'll explain why that would be difficult at best and very, very costly to do each and every time. That doesn't make sense. So that how the court would decide who benefits from having a lake level itself. It's not really, and when you're establishing the special assessment district, it's not for one specific project. The levying of an assessment is for one specific project, and you do have the right to challenge that, as you noted, under section 324.30714, and that section specifically gives notice for that. But it's not a judicial determination of the methodology and a specific cost. It's who benefits from having, what properties benefit from having a lake level. In this situation, and in hundreds of situations throughout the state of Michigan, that is the circuit court's determination. I call it who's in and who's out. In this situation, as it is in many, it's those properties who are on the lake direct and then indirect access. They have some sort of private deeded access.
But I guess
That is not a like having coffee and decide anything. There's some people who come in and say, and certainly in this hearing, we think everybody in Roscommon County should be part of that. We think this is the best lake in the state of Michigan. We think you should be part of that. We think the entire state should be part of that. Everybody should be part of the special assessment district.
Why are you doing it now?
Why are we doing it now?
Why are you establishing a special assessment district now?
Because there is maintenance that needs to take place, not only on this lake and all three lakes in Roscommon County.
But why did that, I mean, if there's things in mind, if there's
Yeah.
projects in mind, why aren't they paired with the establishment of the special assessment district up front?
Because the special assessment district outlives any specific project.
That might be, but I mean, I guess we're establishing one at the outset, and maybe it's the case that that establishment, can persist and make sense going forward for a lot of projects, but it seems like right now we're kind of just establishing one in the abstract.
Right, like they did in
in
Inouye Van Etten, because it can be a tool in the county's toolbox for the levying of a special assessment when it deems appropriate. Under Mr. Ellison's scenario, let's say I had a beaver dam that was built and it's blocking up the lake. And I had somebody go out and take that out, or I want to, and I'm going to spend $2,500. Under his scenario, I'm levying a special assessment. Do I need to go back to circuit court each and every time, notice 4,400 people, which will cost more than the taking out of the beaver dam, by the way, to have the circuit court, Judge Bennett, spend his time going over the methodology of how much each person should pay for the $2,500 to remove the beaver dam?
Well, there is a
That is
process
not-
for that, though, right? I mean,
There's
you
a
have to-
process under Part 30714 that you first cited. That's the delegated authority that after this special assessment district is set by the court, confirmed by the court, then for this continuing operation and management, the specifics of a project takes place. And then you hold the hearing under 30714 where there is indeed notice and an opportunity to be heard to go over the specifics of that project cost, the computation of costs, the assessment methodology for that specific project, and then you levy the assessment.
So let me ask you this.
Yeah.
Are there any costs that can be put upon individuals that have been designated within the special assessment district? We have this district set now.
Yeah.
So can any costs be put upon them without them getting a further opportunity to contest their role in paying those costs? Or does everything, regardless of scale, have to go through that 30714 procedure?
So I'm going to say 307, you can't without going through the 30714 procedure, you can't levy any assessment without that happening. I'm going to give you, it depends though, because so in this situation where this district's been established, no assessments for Higgins Lake can take place without that 30714 hearing. Zero. After that hearing happens, we go through the methodology. How much should the state park pay in relation to a backlot owner, in relation to a marina, et cetera? I'm not saying that, so that will decide there'll be a computation of costs, et cetera. In 2 years, if they spend $57 for a new board and there's a 25-cent assessment to everybody, I'm not saying that there's going to be a 30714 hearing. In every situation.
Because that project has already had a hearing and the costs were different? Or?
Because the apportionments have taken place for that. For sure, in this situation, you can't have any assessments until the 30714 hearing has happened because there hasn't been an allocation of the apportionments.
So
Just
the
like Mr. Ellison-
apportionments apply to, so the apportionments don't just apply to one specific project. They apply evenly to projects regardless of impact on the different parcels, because I can see different projects having different impact.
Right. And so I've been asked this question by, I represent 60 different counties with regard to this, and I've been asked that question. The statute is, so for the specifics of this case, it's a slam dunk. You can't, because there's never been a 30714 hearing. When you're reading, when do I have to have a hearing? Do I have to have a hearing every year, even if I'm spending $25? I look to the section of 307 that says the levying and collection of special assessments should be analogous to the drain code. And so I look to the section, and again, it's unclear in the statute each and every time if you're spending a nominal amount of money, whether you need to do that or not, and if you don't change the apportionments between the property owners. And I realize I keep looking to a screen and that's not where the camera is, so I apologize to you. And so I analogize that to my clients as if you're spending less than $10,000, which is the you know, the nominal amount that a drain commissioner or a delegated authority can spend, and you use the same apportionments that you had in your last 30714 hearing, perhaps you don't have to have a hearing. That's very similar to Mr. Ellison. Every time he gets an $8 assessment from the Saginaw County Public Works Commissioner, there's not a separate hearing for that. It only when it meets a certain threshold.
30714 does seem to contemplate a project specific,
Yeah,
you know, project by project kind of thing. Now, I don't know what the scope of a given project could be. Maybe there's a project has, you know, ongoing assessments, but
Yep.
it does seem to contemplate the delegated authority approving or revising, you know, the cost of the project, you know, or the special assessment role. So it does
Correct.
seem to inhere in that the idea of that we're kind of doing this on a project by project basis.
correct. And that's why the circuit courts already don't really love having 3,000 people noticed and come in for the setting of the special assessment. They certainly don't want to have to do this each and every time there's a levying of a special assessment. And so I think that's where the confusion is. When you're looking at special assessment districts versus the levying and collection of assessments for ongoing infrastructure, there's not a redetermining of the district boundaries itself every time, whether that's the drain code, whether that's Part 307, whether that's an Act 188 district. It's the same district that gets established here by the circuit court that's utilized moving forward.
Now, I mean, if you're in the district,
Yeah.
regardless of the kind of project, are you always going to have some measure of assessment, or can a given project, you know, let's say there's a given project, I'm in the assessment district. Can my assessment ever be zero?
Absolutely. Absolutely. And that was discussed during the hearing.
That's
Yes.
based on the nature of the project. So
Correct.
the fact that I'm in the special assessment district doesn't mean that for every project going forward, relevant to that district, that I will always have an assessment. It'll depend on the project.
Correct. Correct. And there may be situations where a portion of the district doesn't. So we have a lake that has a chain of lakes in Calhoun County. And so there's a couple of different water control structures. Some benefit parts of that chain of lakes that is all one lake for purposes of Part 307 different. The methodology is going to be different. In the Heron Cove case that Judge Maldonado just heard earlier this year and decided on with regard to the Four Lakes project, there's two different special assessment rules with different methodologies for each of them. One for the big project for the Four Lakes situation, and one for operation and maintenance of the continuing operation of those structures. So there's going to be different situations, but it doesn't come back to the circuit court each and every time you have a project.
But it can. There's
If-
an appeal that you can take to a court.
Of your specific
30714.
assessment, but not the confirmation of the district
Right,
itself.
correct. But
Right.
if you, through that 30714
Yeah.
process, if you are, you know, displeased by what your assessment is, what your role is in the given project, or even with the project itself, there's an appeal that you can take by statute.
Absolutely, and that's what the Heron Cove case was that was decided since the briefing took place in this case, was an appeal of those very assessments under 30714.
I don't think I have any further questions. Judge Maldonado, anything further? Okay. Thank you, counsel.
Very briefly, I think we've been fighting about this at length. Houghton Lake's coming up next on all these, but the problem is that there's a fundamental, I think, difference between what constitutes a project. And I thought I heard just now, and I agree with Sister Counsel in that I draw parallels between this program and how the Drain Commission system works. I mean, and in fact, the statute even suggests to look to that for guidance for the courts on this. There are some assessments that I'm paying for in Saginaw County where they are building X, and I'm paying my proportional share of the building of that structure. So think about, in this context, would be the building of a new lake control or dam structure. There are other assessments like the Drain Commissioner one where they have come to me and said, we have a 20-year maintenance project where every year we have to do so much maintenance work and you are contributing X amount of dollars to that in a given year. Meaning, so the project doesn't have to be one build and done. It can be a maintenance style project that can go forward. And the problem that I'm hearing here from Sister Counsel is we can establish the district. We don't care who benefits. We don't care whether it's allocated fairly between themselves. It's just, we want this district and we will determine later how we're going to do that. And the problem is the constitutional standards that are applicable here say that it has to be fairly allocated across the entire district. Now, there can be some different classes and things, but I think you highlighted the very problem. You just asked the question, could my bill theoretically be zero? And if the answer is yes, that means it's not being allocated fairly across everyone in that specific defined district. Those are different districts now. That's the problem that exists. So as I see it, I guess to put it kind of at a 35,000 foot view would be is if Roscommon and Crawford counties wanted to money for building a new lake control structure and it cost $10 million, they're going to say this is the cost of it. This is how much. Here's the group of people that we are proposing would be responsible for paying for it. Here's the formula by which we're going to allocate. And then you have that hearing in front of the circuit court for the circuit court to do a substantive review on whether or not it meets the proportionality and apportionment standards that are required for special assessments. If the county wants to have a project that says we have a 20-year maintenance following that building of that is a separate project that exists. You define that district because as we just heard, and I actually agree with, different projects could have different beneficiaries and different costs to be allocated fairly across all those. So the reality here is the obligation to hold that hearing, the order of operations, maybe we should say, is that the 307-14 hearing should occur before the circuit court hearing on this, not after. Because if it is, all we're doing is the notice that they're proposing is it gets put in the newspaper. And next thing you know, my clients are paying for a pavement of I-75 that they didn't have any notice of. Decisions are made, and I have a 15-day window to appeal from that without having been given any notice as to what the decision on that aspect is. This statute has a structural error in its operation, and that's what I'm asking this court to correct. Absent correction by this court, I'd ask the court for very, very clear guidance on what we're supposed to do because we disagree with what Roscommon and Crawford counties are doing in the way they're creating these never-ending slush funds for the operations of these structures, maintenance and building of these things, that we really don't have a say as to what they are, even though we're the ones footed with the bill. And at the same time, we're also not given any notice as to what that actual cost and what our allocation is before it's kind of thrusted upon us and it's too late. So I'm asking that, so I guess in summary, unless the court has any other questions, is help us. Help us decide what 307 means because there are fundamental disagreements on how the order of operation should go and what the Constitution requires. And when I say common law too, common law and constitutional requirements when laid against 307. Thank you.
Thanks, Counsel.